We need to talk about the rule of law. A podcast by Verfassungsblog and Deutscher Anwaltsverein.
We need to talk about the European Court of Justice. The court has been in the middle of the European rule of law crisis for the last couple of years, and it has called out rule of law violations, especially in Hungary and Poland, multiple times. But the court can't defend the rule of law in the European Union on its own, and it needs institutional partners in this struggle. For example, it needs someone to file cases. Does the European Commission do enough on its part? Who is the guardian of the treaties? The Commission, the Court, or none of the two? The European Council is able to decide on sanctions against member states using the procedure of Article 70 EU, but that tool has not been effective so far. So, do we witness the juridification of a political conflict that puts too much of a burden on the court? This is what we will discuss in this week's episode of We Need to Talk About the Rule of Law, brought to you by Verfassungsblog and the German Bar Association Deutscher Anwaltsverein with our distinguished guests. Katharina Barley is Vice President of the European Parliament. She has held several cabinet posts on the federal level in Germany, including a term as Minister of Justice. Before that, she has been an attorney and a judge. Didier Reynders is European Commissioner for Justice. He has held several cabinet posts on the federal level in Belgium, including a term as Minister of Foreign and European Affairs. And Laurent Pesch. He is Professor of European Law and Head of the Law and Politics Department at Middlesex University, London. I'm Lennart Kokert, a member of Verfassungsblog's editorial team, and I'm very happy to have you all on the show. Commissioner Reynders, to dive right in, the ECJ, which is at the heart of today's episode, in a way, rules about the compliance of member states with European rule of law standards, but someone has to file cases before court may do so, and someone has to enforce judgments. Is that a task the Commission owns up to, and is the Commission still the guardian of the treaties?
No, of course we are the guardian of the treaties, and we organize the process in different ways. You spoke about the infringement proceedings and the way to enforce the decision of the court after that. But so the first phase to go to the court is to introduce an infringement proceedings, and we try to do that in the different situations where we are thinking that there's a real breach to the rule of law. And it was the case in many member states, but it's true that in the last years, it was more and more the case in Hungary and in Poland. And of course, if we don't have a correct enforcement of the decision of the court, we have different tools to try to force the correct enforcement. First of all, of course, to be in touch with the member state, the concerned member states, and if it's needed, to go back to the court. And of course, in all the different procedures, it's possible to do that following the treaties. That's the first situation. But of course, we have all the tools to try to be efficient in our role as a guardian of the treaties. And you know that for the first time this year, it was at the end possible to come with a first rule of law report at the EU level, and so to engage a real dialogue with the member states. And I must say, with a very large majority of member states, since the end of September, we have received many responses with proposals to reform different kind of processes to be in line with the report. It's the case in many member states, sometimes with huge reforms, like in Malta or in Bulgaria, sometimes with very precise. Yesterday, the Minister of Justice of the Netherlands said that we will change the course of the things about the prosecutors in the Netherlands due to the report. We have had a huge debate in the last weeks with Spain on the reforms of in the justice system. And again, we have different tools, of course, to try to do that. And we are hoping that it will be possible to conclude in the near future to use a new tool. I mean the conditionality between the rule of law and the budget of the European Union. But for the moment, it's in the hand of the European Council.
Nevertheless, there are some people that argue that the Commission seems to be more eager to write reports than to actually try to sanction infringements of the treaties. What would you answer to that kind of criticism, Commissioner Reynders?
No, we are doing both. I said, after so many discussions in the European Parliament and in the Council, I was in a previous capacity Minister of Foreign Affairs and European Affairs from Belgium in the General Affairs Council. I proposed in 2016 to organize a peer review on the rule of law. And for the first time, I said it was possible this year to come with a report of the Commission. That's a report not just to put in the library. It's a report, I said, to discuss with the member states, and you will see in the near future different reforms in many member states, because we have a real dialogue with many member states. If it's not the case, if we don't see a reform, it's possible to go to the court. And the main action of the Commission, of course, in such a situation is to go to the Court of Justice. And just to give an idea about the situation in Poland for the moment, we are with some infringement proceedings before the Court of Justice against the situation in Poland. And first of all, for the moment, we are working on the so-called muzzle law. So you have seen that it was possible at the beginning of the year to act about disciplinary procedures about the judges in Poland, and we went to the court to ask interim measures and to suspend all the activities of the disciplinary chambers about the judges. And now today, we have decided also to send an additional letter of a formal notice to Poland regarding the continued functioning of the disciplinary chamber of the Supreme Court, including as regards, because it's a new fact, cases for the lifting of immunity of judges. And we have given 1 month to Poland to respond. Of course, I've said at different times, we don't have exactly the same timeline than Twitter. And so, of course, I know that there are some reactions on Twitter to say there is a situation in one member state, you need to react in the morning, and in the afternoon you will receive the response of the court. No, we try to go to the court with a very robust argumentation. And of course, we try to have full respect for the rule of law. So you know that in the procedure, we need to ask to the member state to respond. Then if it's not satisfactory, we go to the court with, like today, a formal notice, and then we will start the procedure before the court. And I know that sometimes that take years before to have a definitive decision, except if we ask, like in the beginning of this year, interim measures. So we try to act, and we try to receive new tools to act, because when I said that we are waiting for the conditionality and the new regulation of the conditionality between the rule of law and the budget, it was a proposal of the Commission since 2018. And I must say that I was appointed as Minister of Foreign Affairs in my country in December 2011. And in January 2012, we discussed already at the EU level in the Council about the possible sanctions for the first reforms in Hungary. So you see that it's a continuity, but it's not just with report. Of course, we need to go to the court when we have a real concern about the situation in one member state.
Thank you very much. If we look at Poland and Hungary in particular, you will find that an order of interim measures by the ECJ has not really been followed up on until today, one might say. And the Commission hasn't been able to take definitive measures against Hungary. Does it really own up to its task then, Professor Pesch?
Thank you very much for this question. It's a difficult question. Before I try to answer directly, perhaps a bit of a background and context, and in fact, why are you asking this question today? I think you would not have asked this question about 10 years ago. Possibly you're asking the question today because more and more people are asking this very same question. And why are more and more people asking this very question? It's because of what we have experienced in the past 10 years in the EU. I have written about what I have called in my scholarship rule of law backsliding. And it has been in fact identified as a kind of a pressing, if not existential challenge by the European Commission itself for the first time in 2012. So we're not talking about a new problem. In fact, rule of law backsliding has worsened, if anything, since 2012, since it was first identified by the Commission as a pressing issue. By rule of law backsliding, what do I mean? It's very important to understand the unprecedented nature of the threat to the rule of law we are seeing in the EU. I think it's very important to emphasize the deliberate nature of the process. So we're talking here about national authorities deliberately undermining or seeking to undermine checks and balances. Now, why would they want to do this? Essentially, we're talking here about the dismantlement of the democratic liberal state and the entrenchment of the de facto ruling, de facto essentially dominance of the ruling party. I would say Exhibit A is Hungary in the EU and Exhibit B is Poland. Now, let me return to your question, but I think it's important to understand the background. I would submit that the Commission, I'm afraid, I would have a more skeptical, more critical assessment of the Commission's record when it comes to the rule of law. So with respect, I'm going to disagree with Commissioner Reinders. I think the Commission is simply not acting effectively and promptly and meaningfully to actually contain rule of law backsliding. We did mention the ECJ order of 8 April 2020 regarding Poland's so-called disciplinary chamber. Now, Polish authorities are currently pretending that they're not acting in violation of this order when they are waiving the judicial immunity of Polish judges. Surprise, surprise, they have been targeting the Polish judges who have been the most vocal, the most critical about Polish reforms. Now, what do? They have been subjecting these Polish judges to absurd criminal charges, and these criminal charges are brought by people under the control of the governmental coalition. They are formally prosecutors, but as we know, the Minister of Justice is also now, because of changes adopted in 2016, also the Prosecutor General. So there has been an amalgamation of the two roles. Now, these proceedings have resulted in the immediate adoption of disciplinary measures. The last case we have is the case of Judge Tuleya. So we have the disciplinary chamber allegedly suspended by the European Court of Justice, adopting disciplinary measures right now. So disciplinary measures such as suspension of judges, salary cuts. Now, we've seen today a reaction from the Commission, but I would argue, and in fact, an ECJ judge argued the same last week, that the ECJ order of April 2020 is already being violated. So there was another option available to the Commission, which the Commission didn't take, which was to return to the Court of Justice and ask for the imposition of a daily penalty payment. In fact, I'm not the only critical voice when it comes to the Commission's possibly not sufficiently prompt reaction to violations of rule of law standards and ECJ orders and judgments. We saw the Dutch Parliament for the very first time a few days ago adopting a motion calling essentially on the Dutch government to lodge an interstate complaint against Poland due to the Commission's failure to react promptly to the violation of the ECJ order. We have also, to the best of my knowledge, the Commission is yet to react to the voiding of the ECJ judgment of November 2019 by the disciplinary chamber last September. So we're talking here about an allegedly, technically a body which should be suspended as far as judges are concerned, which formally voided a preliminary ruling judgment of the Court of Justice regarding this very body. Now, as far as I know, but Commissioner Reinders can correct me if I'm wrong, the Commission did not formally, officially react to this decision of last September. Now, so also, if I may, I mean, I've just been mentioning Poland, but the Hungarian authorities are still in violation. They have not complied with ECJ judgment regarding the Lex NGO. So we're still waiting for the Commission to bring back Hungary before the Court of Justice to impose financial sanctions on Hungary for their failure to comply with this ECJ judgment. Now, so essentially, I'm sorry for being critical, but in my view, but this is not simply this commission, but also the previous two commissions, when faced with a new threat to the rule of law, essentially the default position has been to do too little too late, I'm afraid. Sorry for being critical, but this is my perspective after years of studying this rule of law backsliding. In the Commission's defense, possibly, and in fact, to defend the EU in a way, is the EU was not arguably prepared or even designed to face this kind of bad faith actors engaged in an authoritarian, essentially, autocratization process. We have seen and we continue to see representatives of Hungarian authorities, Polish authorities, actually seeking to deliberately mislead EU institutions, which is also something unprecedented, we have seen agents of these governments essentially misleading the Court of Justice during hearings at the Court of Justice, which is again something unprecedented. And then these authorities have identified a weak spot in the EU's system of governance, which is the EU's default position to prefer dialogue. Now, dialogue does work when you're dealing with good faith actors, but here we're dealing with bad faith actors, I'm afraid. And when you have a system designed to favor dialogue over action in the short term, very prompt and very decisive action, then what do we see? Well, we saw last year Hungary becoming the first authoritarian country in the EU, according to democracy experts, known as the VDEM network. And I'm afraid Poland is on track to becoming the EU's second authoritarian regime by, let's say, within the next 12 to 24 months. So I would say, I'm afraid what I've seen, if I had to summarize, sorry for the long answer, is too little, too late, too often. Thank you very much.
Professor Pesch has mentioned that, or has held the position that the European Commission has not been acting meaningfully, and you have mentioned Article 259 TFEU, which allows member states to file infringement procedures as well. They are, however, hesitant to do so. Why is that, Vice President Barley, as a former member of the German government? And could that change at some point, as we are seeing motions in the Dutch parliament at the moment? And would that be a good development?
Well, of course, the Commission is the guardian of the treaty, but we are seeing that the member states are becoming more and more well, fed up, if you could put it that way, with the way that some member states are trying to change actually the fundamentals of the European Union, because it is not only anymore a backsliding. It's more than that. It's because a backsliding always referred to, or used to refer to, the member states themselves. And we've seen problems in a lot of member states during the years. We've seen these major problems in Poland and Hungary, but this has a new quality, as Professor Pesch pointed out, but also there is one new quality that is quite recent, that they are actually now trying not only to change their or reshape their own countries, but also the European Union as a whole. They are doing this by saying that the rule of law is not defined anywhere in the European Union, and that therefore it can be defined differently in every single member state. So it is actually a question of subsidiarity, if you want to put it that way. And of course, this is complete nonsense, as we probably all know, but it is a narrative that connects extremely well with a lot of people. And I'm really surprised by this. Within the last week only, I've had 3 very different settings of panels with young people all over Europe, with experts who are actually buying this narrative and are saying, how can we form a dialogue over what the rule of law could mean in one member state or the other, or if we can agree on something. And this is already buying the Trojan horse of Mr. Orban and Mr. Kaczynski, because of course we have a common notion of the rule of law. We don't have a single model of how member states have to organize their whatever, the independence of the judiciary or the separation of powers. There can be different models, but the result has to be the same in every member state. So, and they are trying to actually take over the rule of law notion in the European Union. And this is something that is really absolutely unprecedented and very, very dangerous. And more member states are actually realizing this and are objecting to it, because I think we here probably all agree that the rule of law is the foundation of everything that we are doing in the European Union. Absolutely, basically everything. If it's data exchange, if it's European arrest warrants, if it's even trade policy, it's the base, it's the fundament of everything. And I think if a member state uses this measure of Article 259, it is really in emergency, because the Council, I've taken part of some, of course, has to work a bit like a Turkish bazaar, because you always meet again. And you know very well that if you really are heavily aggressive towards one member state, it's going to come back to you sometime. So, of course, the Council, much more than the Commission or the Parliament, depends on dialogue, which is okay. We have the other two institutions to balance that. But when it comes to the Council itself, that is the reason why happens very rarely. I think it was like 4 or 5, maybe 6 times in history that one member state launched an infringement procedure towards against another member state, because it is really only in very extreme cases. And this, I mean, I really have the highest respect for this decision by the Dutch Parliament, because it really shows how important this is. And I'm married to a Dutchman. I've been following this debate in the Netherlands very closely. This is not an elite debate. This is something that really concerns citizens, also in Germany. Whenever we have discussions here with the public, now only virtually, but before in public with real people present, it always is a topic that is being raised. In every single discussion, people say, I'm a European from head to toe. I support the European Union wholeheartedly. But if we continue to support, to even tolerate governments in the European Union that violate not only the rule of law, but do it deliberately, do it in bad faith, and now do it to reshape in the European Union, this is not what we believe should be the European Union. So there is a pressure from bottom up, I would say, and the Parliament in the Netherlands has reacted to that.
Thank you very much. Let's take a look at the Council for a moment and at Article 7 TEU, which allows for the Council to decide on sanctions against a member state that is found to violate core values of the European Union. Article 7 proceedings have been triggered against Poland and Hungary and are still pending, but they have proven to be extremely hard to achieve politically. Does that mean the burden of preserving the rule of law is exclusively on the ECJ at the moment? And what can how much can the ECJ do from the perspective of the Commission, Commissioner Reinders?
Yes, I will answer to the possibility to act with the Council, because we have 2 possibilities, in fact, the ECJ with the infringement proceedings and the Council. But I must react because the Professor Pech said too little, too late, and he was speaking about first a decision of 8th of April, but it's a decision on the request of the Commission. We have decided to go to the court to ask interim measures, and it was a decision of the court on the basis of a request from the Commission. It's on the basis of an action from the Commission, first of all. And so we have asked to suspend all the disciplinary proceedings. Now there are debates about the 2 possible ways. I know that there are some people saying, why not to go back to the court to ask for fines in such a way? And I've seen also that the new procedure are more in line with another kind of process to lift, about the lifting of immunity. And so we have decided to go again to the court about another part of the muzzle law, because we are sure that we need to have such a solid basis to act against this kind of new procedure. But again, on the basis of a request from the Commission today, I said we decide to send a new letter in the procedure to go to the court about this part of the muzzle law. So on the one hand, you have a disciplinary proceeding, and on the other hand, we have a more criminal proceeding with the lifting of immunity. And so I see the Professor Pech was reacting, but it's a possible discussion. And so now we have taken again the decision to act and not just to make a report, to act and to go again to the court. And again, I want to insist on the fact that a decision of the ECJ is not coming from nothing. Yeah? It's coming from a request from the Commission. I've asked, I'm just from 1 year in my mandate, but I've asked again in the middle of this year to go to the court for interim measures. The same for the procedure about Hungary. We are following all the decisions about Hungary. And now we try to have, of course, a cooperation like with all the member states with Hungary, but just about the legislation on the NGOs, we have sent 2 letters in September and October. If we don't receive a satisfactory reaction from Hungary about the correct implementation, again, we will act. But I know that takes some time. I fully agree that sometimes it's quite long. The other question is about the member states. And I must say that it's the first time that it's possible to have a real debate at the council level about the rule of law. Because I said in my previous capacity, I've tried different times to put the discussion on the rule of law 10 years ago about Hungary on the table of the council. But now I've seen that it's possible with the rule of law report to engage a real debate in the Geneva Council with all the member states on the rule of law. And yesterday we did the same with the justice ministers. It's quite new. It's the first time that I've seen exchanges among ministers about the rule of law in the different member states. The second element, it's true, is the Article 7. And the Article 7 procedure, I took part in all the hearings about Hungary and Poland, and then as commissioner now I try to come with the state of play. But now it's in the hands of the Council. It's possible to decide, but you know that it's difficult to reach maybe the qualified majority or the unanimity in the next phase. But now it's very important to try to see if there's a real majority in the Council to take a decision on this. And it will be maybe the same later about the conditionality, if we have a mechanism about the conditionality. But you see that here also, for the first time, there is a real discussion on the rule of law at the level of the European Council, at the level of head of state and head of government, because you have seen that on the proposal of the Commission from 2018, it was possible to have, of course, a real support of the European Parliament and a qualified majority in the Council to do that. And now, of course, there are discussions in the hand of the German presidency about the way to go forward with the budget, with the MFF and the Next Generation EU. But again, we have 2 possibilities, main possibilities to act at the Commission level, to go to the court, and we are doing that. And of course, it's true that to have a robust argumentation and to have a success before the court is sometimes longer than it was maybe the hope of many participants in many debates. And on the other hand, we need to convince that the rule of law is not just for the Commission, the Court of Justice, or the Parliament, but it's also for the Council. And in the Article 7, we try to do that, but we try also to do that with the rule of law report and maybe tomorrow with the conditionality. It's the first time that we have such a kind of debate with the member states. And I want to conclude to say that I will go also to all the national parliaments. I've started to go to the different national parliaments to discuss about the rule of law, not only with the majority, but also with the opposition. And I know that we try to do that with many kind of other stakeholders in many debates with the civil society. But it's very strange. For the first time, due to the pressure that we have put with the rule of law report and with the proposal of a regulation on the conditionality, it's possible to organize a real pressure at the council level. Of course, I don't know. And the last point, maybe because I don't want to don't answer on this, I have followed so very closely the discussion in the Dutch Parliament. If we receive a request from the Netherlands as a member state, of course, you know that it will be a request first to the Commission to organize a discussion with the concerned member state and, in such a case, the Netherlands, and then it will be possible to go to the court. But till now, it's a debate at the Parliament level in the Netherlands. We will see if we will have an action coming from the member states or from the Netherlands later. I don't know. We will see. It's possible, but debates in national parliament, I've seen a lot of time also in a different kind of national parliaments about the rule of law, but we will see. And if it's the case, we will do the job, of course. We will also at the Commission level do our part of the job, because there is a procedure in the treaties for the Commission in such a process on the basis of requests by a member state.
Thank you. I've seen a reaction by Katharina Barley on this.
Yes, thank you very much. I just wanted to ask you for your opinion, because the German presidency had announced to put the monitoring, the results of the monitoring, on the agenda of the Council, 5 countries at a time, and discuss what comes of it, out of it. And apparently, in this mandate in December, it's maybe not going to start, because all the other issues still have to be solved, and that will probably take up all the time that there is left. So my question would be, if you have a feeling that the Portuguese presidency will take that over, or do you think this will kind of die slowly? I know, of course, you are going to all the member states, and I think that's a very good idea, but you know also that we as a parliament thought it would be helpful to include country-specific recommendations into the monitoring report, to have something more concrete to discuss about. So maybe you consider that for the next time.
No, I want to be very concrete. We have organized such a debate. So on the basis of the first annual report on the rule of law, published on the 30th of September, it was possible to organize first in the Geneva Council a general debate, an horizontal debate in October. But in November, we have had already a peer review on 5 member states, so Belgium, Bulgaria, Czech Republic, Denmark, and Estonia. So we have started in the protocolar order, except Germany, due to the fact that the presidency for the moment. But with the Portuguese, we'll continue with 5 other member states, including Germany and France, to give 2 examples. But we will continue. It will be the same with the Slovenian presidency. So the goal is to organize a discussion member state by member state, because we have a country chapter about all the 27, during maybe 5 presidencies. But of course, we have started also in the last days the preparatory works for the second report, because you know that it's a cycle now. So in fact, we try to install a permanent debate about the rule of law. I want to say that it's quite new. Also about individual member states. I remember I have had also the opportunity to serve as Minister of Finance during 12 years. We have had constant debates about the budgetary situation of the member states, the structural reforms, but not about the values, about the Copenhagen criteria, about the rule of law. And for the first time, we install such a kind of debate. But what is true, that in a large majority of member states, we have punctual concerns, and we engage a real dialogue to try to improve the situation. And you know that in Germany, like in many other countries, we try to see what is possible to do to improve the situation on some specific issues. And there are debates on that. I've had debate in Germany, like in Netherlands, like in other countries, about the independence of the prosecutors, to give an example. And is it needed to change or not? There's a real debate. In some member states, we have a more systemic issue. And that is more difficult. And when we have a systemic issue, we need to go to the court first to receive a positive answer from the court about infringement proceedings. But we try also to explain the situation during the Article 7 procedure. And you know there, it's more in the hands of the Council. And on such a procedure, we have had a state of play during the German presidency. And we have discussed about the possibility to organize hearings. It's maybe about that you are speaking about the cancellation on the agenda. And it will be maybe not before the end of the year, it will be maybe next year. I must say that a hearing with virtual tools, it's not easy on the table. But we need to continue that. But it's in the hand of the Council, of course, to take a decision. And then we will manage the same situation about the conditionality. But it's true that it's very important to engage a real debate, member states by member state. And not just to exchange the best practices, but to see what are the criticisms coming from the other member states about the situation in one. But in the majority of the member states, it's with very specific concerns on different elements. It's true that in other member states, it's a more general approach, a more systemic approach. When we discuss with the Polish authorities about the independence of the judiciary, we have totally different views. And we are sure that we need to continue to proceed before the court.
Thank you very much. I think one institution we've left out so far has been the European Parliament. What is the role or the place of the European Parliament in the current rule of law struggle, Vice President Barley?
Well, when it comes to rule of law, the Parliament has less possibilities than the other two institutions have. So we can launch an Article 7 procedure, which we have. We can discuss and issue resolutions. We can take part in any kind of public discussion, but we cannot, for example, launch an infringement procedure, which we would love to do. We are unfortunately not involved very much in the new conditionality mechanism either. And this, I have to say, also has something to do with this approach by the Hungarian and Polish government and the pressure that they are putting on the European Union, because they have this narrative: rule of law is a matter of subsidiarity, and they have another quite new narrative that I've only noticed during the last two weeks, which is actually to say the Council took a decision in July on the rule of law conditionality, and then the Parliament, well, what would you say in English? Manipulated it was one of the notions that people used. Polish politicians, and also on a panel discussion, a Polish professor who's obviously close to the Peace Party used. So the Parliament is then manipulating or obstructing or destroying the decision of the Council. So what they are trying to do is, unfortunately, I believe, following a bit the German Constitutional Court and its decision of the 5th December, to say the interpretation of European law and taking decisions in the European Union, it should be in the hands of the Council, in the hands of the member states. They have referred to that politically before, but now they are trying to build a narrative that actually the true will of the European Union is being enshrined in decisions of the Council, and the Parliament is actually kind of a disturbing element, a destructive element. This is what they are trying to come up with. So this is one of the reasons why I was very unhappy that the Parliament does not play any significant role in the new conditionality mechanism, because I'm absolutely convinced of the good faith of Commissioner Reinders and Commissioner Jourova, but of course the Commission is also a body that is kind of well, that has to arrange with the Council in practice, and it's not by accident that it's mostly the European Parliament that is the most vocal about the rule of law, because, well, we are elected by the people, and we're only responsible towards them, and so we are able to act, and we are, I think, also expected to act a bit differently. So if it's only in the hands of the Commission and the Council, I think there is this danger of finding compromises, having a dialogue. I mean, I wanted to become a diplomat. I think dialogue is terrific, and compromises are fine. But as Professor Pesch also referred to a bit, you can have compromises on anything, on really anything, on financial issues, on posts, on issues, but not on the fundaments of the European Union. There is just no way of compromising on the rule of law, because it would destroy the fundament of our our union. So this is why I would prefer the European Parliament to play a more important role.
Thank you very much. I think at a certain point in every discussion about the rule of law struggle or crisis in the European Union, one always hears we need to go to the court, we need to call on the ECJ. Professor Pesch, do we witness the juridification of what is a political conflict in essence at the moment?
Interesting question, not an easy one. I think I would like to, before I answer this question, there was another question I wanted to answer, if you don't mind me answering both at the same time. It's about also the Court of Justice, whether the Court of Justice can actually help with what I have called rule of law backsliding. I think it can do a lot to contain rule of law backsliding, but the court cannot act if it doesn't get a sufficient number of requests from the Commission. So essentially, there is a lot the Court of Justice can do to contain rule of law backsliding, but we need, first of all, a proactive Commission willing to act promptly and with actions of the appropriate scope. And to some extent, I think one of the key lessons of the past 10 years of rule of law backsliding is when it comes to the destruction of judicial independence, time is absolutely of the essence. Now, what we are seeing today is Polish judges being suspended under false pretenses, being subject to pay cuts. We're seeing lawyers being suspended. We see the right of practice of one Polish lawyer, which was unlawfully suspended. We have seen Polish prosecutors being demoted, being removed from their position, or being moved 400 or 500 miles from where they work. So time is absolutely of the essence because we have real victims of rule of law backsliding. Now, it is true the Commission has initiated, certainly the Commission is much more active than the Council. Don't get me started on the Council. But this is because I'm a friend of the Commission that I'm being very critical of the Commission. Now, there is one example where the Commission did exactly the right thing at the appropriate speed. And this is in fact when the Commission was faced with the purge of the attempted purge of the Polish Supreme Court. And we saw in that very case exactly the template the Commission should seek to emulate in every single instance where judicial independence is under attack. Now, just to give you some dates very briefly, we had a Polish legislation adopted in April 2018, infringement action launched in July 2018, and the action referred to the Court of Justice in September 2018. I would like to see the same kind of speed in relation to the muzzle law. We haven't seen this kind of sense of urgency as regards the muzzle law, and the muzzle law, in my experience, or at least as far as I can see, I have never seen such a blatant attack on the most fundamental elements of the EU legal order. For me, the muzzle law essentially has organized a polexit from the EU legal order. This is why I've been very critical of the lack of what I've seen from the outside. There is no sense of urgency also in relation to Polish judges being suspended, being harassed, being bullied, being intimidated, not only by Polish authorities, but by also the media outlets they control. So this is why we need the Commission. I'm afraid the Commission is doing a lot, but it needs to do more. Why? Because we are in the face of a very unprecedented threat to the most fundamental elements of the EU legal system. So I would say this is in fact what the Commission did in 2018. I'd like to see more of the same in relation to every single measure targeting the judiciary. And I can think of plenty of additional infringement actions which could be undertaken by the Commission. I've heard the argument that the Commission is keen not to overload, and that's not an argument made by Commissioner Reinders, it's just an argument I heard during discussions, that we should not overload the Court of Justice with infringement cases. But I don't accept this argument. In fact, since the rule of law crisis in Poland began, let's say at the end of 2015, we have had essentially an infringement case on judicial independence ground per year. This is good, but not good enough, I'm afraid. In the case of Hungary, we have had less than one infringement action per year since 2010 as regards values laid down in Article 10. Again, not good enough as far as I'm concerned, because after 10 years of relative inaction, Hungary is no longer a democracy according to democracy experts. This is why I'm just saying again, time is absolutely of the essence. The court can do a lot to contain the damage or attacks on the rule of law, but we need the Commission to submit more applications for interim measures. I do salute the application for interim measures submitted by Commissioner Reinders as regards the disciplinary chamber. We will have to agree to disagree. I think, as far as I'm concerned, in agreement with ECJ Judge Savian, the ECJ order of April 2020 is being openly violated with disguised disciplinary measures resulting in the immediate adoption of disciplinary sanctions. We need to do more to save Polish judges from an authoritarian government keen on destroying judicial independence. Time is absolutely of the essence. The Commission can do a lot more, I think, and the Court of Justice is ready to help, but the Court of Justice needs applications. So let me emphasize again, sorry, at the risk of repeating myself, that time is absolutely of the essence because we have real victims of what I have called rule of law backsliding.
Maybe if I may, on different points. First of all, because I was listening carefully to Professor Pech, but also to Katarina Barley, I want to give maybe an argument to Katarina Barley about the narrative that it's possible to receive from different actors about the conditionality. Hungary has created a similar narrative for the distribution mechanism of refugees, and the Court of Justice rejected the Hungarian request to have an annulation of the EU legislation for the same kind of violation of the EU Council, the European Council conclusion. So you need to continue to work in the same way, because it's not because there's a narrative about the violation of the conclusions of the European Council that there is a real argument. And it was the case about the asylum procedure. It was possible for the Court of Justice to reject the argumentation of Hungary about that. Of course, the reference is the EU law and not just the conclusion of the Council. The second element I want to raise, it's useful to have, like you have done many times in the European Parliament, a pressure coming from the European Parliament. It's a political pressure. We are knowing that for the moment, the Article 7 it's first of all a political pressure to put the problems in the hands of the member states. We need to do the same at the national, at the level of the national parliaments. It's also a problem with the political pressure in the political parties, because it's also a political issue for the different political families to be confronted with the rule of law in some member states. And about the actions before the court, I don't want to say that we are doing all what is necessary in a good timing, but we try to, again, to go back to the court now. Today we have to take the decision to go back to the court about the so-called muzzle law. But to give us an example, I've seen during many years discussions about the so-called golden passport. I'm in charge since 1 year, the Commission. I've started from the beginning of this year a discussion with Cyprus, Malta, and Bulgaria, because there's also a problem in Bulgaria, about the golden passport. We have seen that it was very difficult to reach an agreement for a phasing out. And at the end, we have decided, after a dialogue with the two member states, to go to the court. And it's very clear. Of course, that takes some months. But if you compare with discussions in some years, about Hungary, it's quite the same. I said, we have had, I remember that in the Geneva Council in 2012, in the beginning of the year, in January and February, discussions already about the possible use of Article 7. And so what is new for the moment, maybe due to a real crisis about the rule of law, it's that we have the capacity to organize a real debate on the rule of law and the real actions, not only before the Court of Justice, but also with the member states at the level of the Council. And we are knowing that there are a lot of things in the hands of the Council. It's not by coincidence that we have for the moment a real blockage about the MFF and the Next Generation EU due to the fact that two member states, and maybe with a third one now, two member states doesn't want to have a conditionality between the rule of law and the budgetary situation. And I must confess that I'm in charge to install the new European Public Prosecutor Office. And so we'll try to start the operations at the beginning of 2021. We are in discussion with all the member states to do that. But you know that we have 22 member states on board, not all, some for classical reasons of opting on in criminal matters like Denmark, Sweden, or Ireland. But Hungary and Poland are not on board. And if we have started 2 years ago to discuss about the conditionality, it's for a part due to that. to the fact that it was impossible to have Hungary and Poland on board of the new European Parquet, European Prosecutor Office. It's quite very, very strange. But now we are able to go not only to the court, but to engage a real debate with the member states. And again, in the Council, at the level of some national parliaments, you have explained again the situation in the Netherlands, but we will do that also in all the national parliaments, because there is the opportunity to discuss not only with the majority, but also with the opposition. In Poland, to be concrete, we have had many contacts with the Senate, because you know that it's not the same kind of majority in the two assemblies for the moment in Poland. So again, it's true that it's important to go to the court, and I want to confirm that I don't want to use the argument of the overloading of the court. I'm sure that there is a real openness in the court to receive actions from the Commission about the rule of law. I've had the opportunity to discuss a lot of time with the members of the court. I'm sure that there is a real openness from the court to receive different requests from the Commission about that. So it's not a reason to don't go to the court. We need to do that. But again, I was given the example of the golden passport, because I know that there also it was a very long discussion. And in some months, we have tried with the new Commission to say, we engage with the member states. If it's not with a real result, we go to the court and it's done.
Thank you very much. Any reactions to that?
Well, we don't have very much time left.
Yes.
I would love to know, now that we have Hungary and Poland blocking the financing with their veto, can we be sure that it is not on Article 7 that a so-called compromise will be found?
If you want, it's possible to say that I'm sure that on both sides, the Parliament and the Commission, there is no intention to move on the conditionality first. We have a very good compromise, if I may. I know that it was better for the Commission and certainly for the Parliament to work with a reverse qualified majority, but we have a broad scope, we have a possibility to act, and I'm sure that we have a good solution coming from the trilogue on the conditionality. So there's no intention to move on this. On the Article 7, the procedure are ongoing. And so the only one way is to continue to organize hearings and state of play. And then it will be possible or not to have a majority to take a decision. But I don't see an intention to organize a compromise on this. The only one way is to convince the two member states, there's only one now, to agree on the budget. But I've said some time ago, and I know that all the possibilities are on the table. It's in the hands of the German presidency for the moment to try to discuss and to convince. So it's we have made the job at the Commission level. It's in the hands of the German presidency to try to convince the two member states. But I've just recalled that some years ago, for budgetary reasons, when it was impossible to act with 27 member states, at that time it was with UK, without Croatia, the discussion was to organize a process with 25th. And so I don't want to do that. Of course, our request is to have an agreement of the 27 member states about the budget, but all the possible solutions are on the table. If it's needed to find new creative solutions, why not? But certainly not against the rule of law, and certainly not against the conditionality or the actual procedure that we are organizing. And we will see. The main issue is to see if it's possible for the German presidency for the moment to convince the two member states to agree on the MFF and the Next Generation EU. If it's not, we need to think about creative solutions, but for the budget, to save the budget, because you know that we need to organize a recovery in Europe. We have huge problems in many member states due to the pandemic and due to the social and economic consequence of the pandemic.
Vice President Barley, Commissioner Reinders, and Professor Pesch, thank you very much for being on our show today and for the exciting discussion.
It was a pleasure. Next time.
Thank you too.
And thanks to all of you for listening to We Need to Talk About the Rule of Law. Please join us again for our final episode on financial sanctions and the State of the Union next week. See you on Wednesday.